All right, everyone. Good morning. This is Judge Alyssa Perez presiding over the 210th District Court civil docket for September 24th, 2025. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Nanez, would you call our first case, please?
Yes, ma'am. On page 2, calling cause number 2024 DCV 4695, Funding Circle USA et al. Versus HDZ Auto Connect et al. Announcements, please.
Good morning. This is Erica Stickney on behalf of the Plaintiff Funding Circle USA, Inc.
Good morning. And is anyone here on behalf of defendants? I know we are set for default. Anyone in the waiting room, Mr. Nanez?
No, ma'am.
We're set for default. It looks that motion for default judgment was filed August 19th. The order setting hearing was a month ago. Ms. Stickney, you may proceed.
Thank you, Your Honor. We filed our petition back on October 11th, 2024. There are multiple defendants in this case. We served the corporation by serving the Secretary of State on March 26, 2025, and the Secretary of State forwarded it on April 3rd, 2025. We served the individual defendant, Anthony Hernandez, on April 16th, 2025 by personal service. Daniel Hernandez was served on April 22nd, 2025 by personal service. And Adrian Hernandez, excuse me, was served on June 13th, 2025 by alternative service. We attached it to the front door in accordance with the order that was entered by this court on June 10th, 2025. We've attached to our motion for default judgment the military affidavits for the 3 individual defendants. Nobody's in the military presently, and we're seeking damages in the amount of $71,412.54 at the interest rate of 18% for pre and post judgment interest and attorney fees in the amount of $1,200. And I would ask that the court take judicial notice of what's on file with the court.
All right, thank you, Ms. Stickney. And I just wanted to make sure the motion for default judgment was filed in August, correct? That's when you all filed this.
I believe so. Let me enroll at the top. Yes, April 19th, 2025. I just said April.
That's my fault.
August.
That's my fault.
I'm so sorry. August.
Everybody
April
take
on
note.
mine.
There's something about April. I don't know. Anybody has a big on April? Well, yes. Okay. So thank you. Do you have anything else, Ms. Stickney?
No, that's it, Your Honor.
Okay, so the court has reviewed the motion and all of the attachments will be admitted for purposes of this hearing. The court will also take judicial notice of all the documents in the district clerk's file in this case. Will grant your request for default judgment as indicated. I haven't gone through all my emails this morning, so if you haven't forwarded a proposed order, a proposed default judgment, please do so and I will sign off on it, file it with the papers of the court.
All right. Thank you, Your Honor. May be excused.
May have a good day. Who's next?
Judge, also on page 2, calling cause number 2024 DCV 2550, Karina Calvo et al. Versus Jeffrey Hayes Rodriguez et al. Announcements, please.
Good morning, Your Honor. Omar Silva from the law firm of Daniela Libanati on behalf of Ms. Karina Calvo et al.
Good morning.
Good morning, Your Honor. Jimmy Ray from Dawn Ray on behalf of the individual defendant.
And Monica Perez on behalf of Defendant USAA.
Good morning, everyone. Final civil pre-trial. How are we doing? We're set for trial in October.
Your Honor, if I may speak, I think I've been the holdup. I've got a new adjuster on this case and an associate that was working on it that left, and I am hopeful that we can get this one resolved within the next week or so.
Great. Well, that's optimistic. So here's what I would like to do, just because I know that our trial calendar is, I'm not really hearing that this is likely to go in October, but just to make sure that things are clear for the court, let's do a reset of the final civil pretrial conference today. Let's see, the 24th. Could we do October 15th? Well, that's just a week before your docket call. Why don't I just let you all figure it out and I'll check in with you all on the 22nd? How about that? Unless you all want to come back sooner than that to tell me that everything's been taken care of and we just need some kind of disposition hearing.
I think,
Oh, sorry, go ahead.
go ahead. No, go ahead.
Judge, I mean, we'll certainly file a notice of settlement and we can email your court coordinator once, I do think we will be able to wrap this up.
Okay.
So we can get off the court's docket and just get an EOJ or friendly suit, which would probably be what would be needed.
Yeah, so I'll leave the docket call as is. I'll just leave that as is as our marker. Why bring you in just a week before?
Okay.
Not a big difference. So unless anybody has a problem with that, we'll see you at the docket call, but I'm hearing that we may not need to go to trial.
That's what we're hoping, Judge.
Okay, well, great. Check your April calendars next week. If you don't have anything else, we'll see you next time, okay?
Thank
Right.
you, Jen.
All
Thank
right,
you.
take
Thank
care.
you, Judge. Can we be
All right.
excused?
May we
Yes,
be excused?
yes, have a good day. Good to see everybody.
Thank you.
All right, who's next?
Judge, on page 2, Bama Page, calling cause number 2023 DCV 342020, Erica Favela et al. Versus Damon Teague. Announcements, please.
Your Honor, Mark Davis, represented plaintiffs Erica Favela and Alfredo Lim. We're ready to proceed on a default judgment.
And is there anyone here? Good morning, Mr. Davis. Anyone here on behalf of Damon Teague? Is there anyone in the waiting room, Mr. Nunez?
No, ma'am.
We had any contacts from that individual? No?
No, ma'am.
Okay. All right, Mr. Davis, I have a motion for default judgment filed back in October of 2024. You may proceed.
Thank you, Your Honor. The defendants were served by substitute service. We had a difficult time serving the defendant. I think that it was avoiding service. The service was pursuant to an order by you for substitute service, and there was a notice by posting on a house where it should be noted that the defendant's car was parked at the time. We ran a license plate check. Also, there was other cars that were licensed to the children of the defendant. So we feel that the service on the defendant pursuant to the substitute service order was calculated to reasonably apprise the defendant of that. And that service was more than a year ago. Judge, this case is a case involving a piece of land purchased by my clients on a contract for deed. The problem was there was underlying wraparound note that was not being paid timely. And however, my client has paid off the property and is not able to get a good deed, even though it's been paid off. More than 4 years have elapsed. So even if there was some claim for an outstanding debt, their statute of limitation is passed. So we're asking the court to enter a default judgment stating that the property paid for by my client on the contract for deed is theirs. They have an unencumbered fee simple interest in the property, and a judgment for $29,000 for clearing the other liens that were against it.
All righty. So I have reviewed the motion and the attachments, the exhibits of the affidavit in support of the attorney fees, non-military affidavit, the proof, the order of substitute service, and by posting. So with that, I'm going to grant your request for default judgment, taking judicial notice of all the documents in the clerk's file. If you would please, Mr. Davis, again, I don't know if you have already forwarded one, but if you don't already have a proposed order, please send it to Mr. Nunez so I can sign off on it.
Okay, thanks, Judge. You've got it. I've already sent it to you. I sure appreciate your time.
Thank you very much. You all have a good day.
Thank you.
All right, who's next?
Judge, going back to page 1, we have Mr. Harris here covering for Mr. Huffman. Mr. Harris, are you there? Mr. Harris, there we go. Page 1, Judge.
Sure.
Calling cause number 2024 DCV 4744 JP Morgan Chase Bank NA versus Nolan Figueroa. Announcements, please.
Don Harris for the plaintiff.
All right, and is anyone here on behalf of Nolan Figueroa? Anyone in the waiting room, Mr. Nunez?
No, ma'am.
let me see here. There is a notation here. This was heard back on the 16th of July. Uh-huh. Oh, here's what's going on. Yes, okay. Thank you, Ms. Hernandez. So yes, there is a notation. We were set back in July, and I believe the court heard your default motion. What we have not received is your order, and that's why it was reset for default.
Yes, Your Honor. I'm showing up with my hat in my hand, as we old guys say. I am very, very sorry that that did not get to you. I thought I did everything I could, but it wasn't enough apparently. But I think I have gotten it straightened out with Miss Hernandez. I'm not sure if she has handed you that order or not yet.
No, she handed me the email that says, I've been asking for this order for the past 2 months and I don't have it.
Okay, I am in contact with my office, Your Honor, and they are on that as we speak, and I am so sorry that it's taken this long.
Okay, so get the order in today so I can sign it. Okay,
I will, Your Honor. I appreciate your patience.
thank you very much. Have a good day.
Thank you, Your Honor. You too.
All right, who's next?
Judge, everything on page 1 has been resolved. We'll be moving to page 3. Calling cause number 2024 DCV 5493, Wells Fargo Bank NA versus Christopher Natividad. Announcements, please.
Carl Smart here on behalf of Wells Fargo.
Michael Castro on behalf of the defendant.
All right, bear with me one second. Okay, let's see. We are set today on the motion for summary judgment filed back in July. And it looks like there was an objection, defendant's objection, filed on the 17th. Let me open that one. Mr. Smart, well, hold on. Let me see the objection because that one I had not read. So, Mr. Castro, you're objecting to some of the summary judgment evidence. Maybe I should start there.
That is correct, Your Honor, and I could kind of boil it down if you'd like for me to. I know it's you might not have had a chance to review our response, and if you need to take it under advisement, I understand. But basically, our argument is basically there's no loan transaction history here. There's no accounting of how we got to the balance. This is not a credit card case like you normally see. But however, all we have basically is a alleged loan. There's no evidence of a disbursement of the loan. There's no evidence of how we arrived at the current balance to the loan. So we don't believe there's enough evidence here to grant judgment at this time. So we're asking the court this morning to deny the motion for summary judgment and set this for trial at a future date.
So let me ask, in terms of just reading the title of your pleading or your objection, objections to evidence. So are there specific exhibits or items that you're objecting to that were presented in Mr. Smart's motion for summary judgment?
Not per se to the evidence per se, but to the lack of evidence, I should say, the lack of the accounting history. So we don't believe that there's enough there to rise to a level of summary judgment.
Okay, so now let me, before I consider the remainder or if there's any more of your response, let me go back to Mr. Smart. I just wanted to make sure that if there were specific items that you were objecting to, that I addressed that before we got into the meat of his argument. Mr. Smart, you may proceed.
Okay, Your Honor, this is a motion for summary judgment based on a default for a personal loan made from Wells Fargo to the defendant in this case. We've included the affidavit of Lisa Ross. Ms. Ross is a longtime employee with Wells Fargo. She testifies that she's familiar with how Wells Fargo keeps the records and with the records of the defendant in this particular matter. She's included 3 exhibits. The first is the loan agreement itself. The second is the statement from September of 2023. And the final is the statement from January of 2024, showing the amount that Wells Fargo is seeking of $21,194.32. I believe that the statements themselves would allay any fear that the court might have that the matter was not dispersed, or the amounts were not dispersed, as it shows that there are balances due, and I believe that payments are being made at that point as far as the first exhibit or the first statement would go. I would say that they have not actually presented any evidence. If they're going to say that this loan was never dispersed, that they never received the funds, a simple affidavit from their client would pretty easily rectify that and say that it was not, I never received this money. We're saying that they did get it, and we presented evidence that they did get that they did get those funds. The final statement that shows the amount also includes a notice that the account has been accelerated. So I believe that we've met any burden that we need to as far as that goes. We've included the declaration from Tom Sellers. He's another one of the attorneys with our office. He's been with our office for 14 or 15 years, charges $119 or $190 per hour. We're requesting $800. So I believe that's more than reasonable for the level of experience and the amount of time that Mr. Sellers has put into this. They did do the response as opposing counsel said. To start, biggest, I think, issue that I have with their response is they don't present any actual evidence. They one of the things that they argue is that the court has to assume that all of their evidence is true. Well, they don't actually produce any evidence, and so that's the issue. We've shown the amount that's due. We've shown that there's a loan. We've shown the contract itself. We've stated in the statements that she's failed to or he's failed to remit payments. Part of their argument is that the affiant is not an attorney. We don't ever claim that she's an attorney, just that she is an employee with Wells Fargo and that she's personally familiar with these documents. They complain that the affiant testifies as to the amount due. Again, it is directly from the exhibits. So I believe, again, that we've met our standard for summary judgment here, Your Honor.
All right, Mr. Castro, anything else?
No, nothing that I haven't already said, Your Honor, just in regards to the lack of accounting of how we arrived at that balance.
So let me understand, Mr. Smart, when I know there's a dispute, I guess, about the disbursement, but there were payments made on this loan?
I believe if you look to the statements that we've provided to the court, and let me just double check to make sure that I'm not, I want to be looking at what I'm actually telling to you. The statements that we provided to the court, which would be Exhibit B to Exhibit 1, shows that a payment was made on that. It's because typically that is the accounting that shows the final time a payment was made on the account.
So in terms of
and it says that a payment was made of $445 in, I believe, June or July of May or June of 2024. So that's, again, if there wasn't money dispersed to her, or to him, I'm not sure entirely why he would make payments back.
But you said there's one payment?
That's one payment that we've shown. Typically, we do only provide a limited amount of account statements. It's a little judicial economy there, and that I don't want to provide, potentially with some of these loans and some of these credit card issues, I could provide you 10 years of statements. That would be, I don't want to give you 5,000 pages to potentially for you to look through. I believe that we just simply need to prove up that there was a loan and that it was not paid back.
Okay. All right.
Yeah, I'm trying to respond.
Hold on, Mr. Castro. Do you know how many payments were made?
Are you asking me or Mr. Castro?
Did Wells Fargo receive one payment, or did Wells Fargo receive a year's worth of payments? Do you know?
I do have, the complete file here with me. The account begins in, it looks like the first statement that I have is from February and then of 2023. So roughly a year's worth of payments were made, Your Honor.
All right, Mr. Castro, go ahead.
Your Honor, obviously that evidence that Mr. Smart's testifying to is not before the court. The payment that he referred to in 2024 is not part of their evidence that they presented attached to the affidavit. I only see one statement that's showing a payment, and that was made in 2023. So the payment that he referred to, that was in 2024, that's not before the court either, Your Honor. And so that's really what I'm arguing here, Your Honor. There's no accounting. There's no good accounting here of how we arrived at that balance. He's referring to payments that are outside of the of the evidence presented. Again, we don't know what credits were given, what credits were made. We're not contesting. When I stated earlier that there's no evidence of a loan disbursement, I'm not saying that there was never a loan disbursement. I'm saying there's no evidence here that shows what the starting balance was, how many payments were made, what dates those payments were credited on, how they arrived at this ending balance, other than two statements, an arbitrary statement of in 2023 of a payment being made, and then a final charge-off statement, Your Honor. So that's what we're arguing here this morning, Your Honor, is we don't have enough here to know exactly what the balance is, if the balance they're actually pleading for, that they're requesting this morning is accurate. So don't believe this their evidence that they've attached to the affidavit rises to the level of a summary judgment.
Anything else, Mr. Smart?
I just want to correct something that I did say, that the final payment that we did receive is reflected on what I gave to you. That was in September of 2023. So I did misspeak. The final statement was in 2024. So I have roughly 6 months worth of payments in my possession. I don't believe that's necessary. Again, Your Honor, we presented evidence showing the amount that's actually due. They have not contravened that evidence. They're simply saying that's not enough. They haven't actually said, I don't owe this. If they believe that a payment was not made or was not credited or something along those lines, that the loan was never dispersed, it would have been very easy on their part to say, I didn't make this payment, or I made this payment and I don't believe it was credited properly. This is not the correct balance, or I never received these funds, those types of things. But because of that, there is nothing contravening this. So we have met our standard, the standard for summary judgment on this.
Okay. All right, Mr. Castro, do you have anything else?
Nothing, Your Honor.
Thank you very much. I am going to take it under advisement at this time. I don't anticipate it's going to take me very long. I just want to make sure I go through both of the pleadings in light of your arguments today, and to make sure I fully review the objection and response to the summary judgment. You all have a bench trial date. It's in January of 2026. So just FYI.
Thank you.
All right. Thank you for your time.
All right. Thank you.
Yeah.
Have a good day.
You too. Bye-bye.
Who's next? Mr. Davis, did you have something else?
Yes, no, I didn't realize it, but I do have a 2024
a
case.
final status, and Mr. Saroldi is here. Mr. Ortiz Saroldi. I see you on page 3.
Good morning, Judge.
Good morning. Let's go ahead and call that one. Well, it's 2024 DCV 2479, Christopher Suarez versus Angelica Aro. May I have announcements, please?
Your Honor, Mark Davis representing Christopher Suarez.
Good morning, Judge. Mario Ortiz Aroldi, representing Ms. Haro.
So it's still here. I need an order of non-suit. Can you please send me an order of non-suit? Please, we can get this off the docket. If that's
I'm
where
glad
we are.
to. Judge, I have a Rule 11. I think there was some period of compliance here, and I'll check it right out when I get off of Zoom. But I think if it's been complied with, we can dismiss it. It's a partition suit, so I have to make sure that title is clear.
Okay, well, let me see.
Refinance and so forth.
We did forward the Rule 11 judge to the court back in July. I asked my office to re-forward it to you now, just in case the court did not see the Rule 11.
I do remember that, which is why I thought this case was resolved, basically non-suited, and so we were going to close it out, but we didn't have an order, and now I'm kind of hearing from Mr. Davis that there are some things that need to be verified before we're at that stage. So for my purposes, I'm just going to say this, the ins and outs, I'll reset the final status conference for 60 days. I don't want to do 60 days. I want to do 30 days because unless you think you need 60 days, Mr. Davis.
No, I don't think we do, and I'll call Mr. Saroldi right after this hearing.
Okay.
Judge, I would recommend 60 days only because I know that there is a couple of things that need to be finalized, and since we're dealing with a bank of assuming a loan, they can take a little bit of time. Mr. Davis,
We'll do November 5th. So if you all have things squared away before then, by all means, if that means a non-suit, send over the order or whatever is dispositive
Sure.
of the case, okay? But I'll give you some time. That's fine.
okay.
Thanks,
Mark,
gentlemen.
thank you. Mark, if you give me a call, thank you.
I'll call you right now. Thank you.
All right. Who's next, Mr. Nunez?
Sorry, Judge. Page 3, calling cause number 2024 DCV 0276, Graciela Armendariz de Parra versus Trenton Cantrell. Announcements, please.
For plaintiff Victor Biganowski and Zachary Biganowski.
For defendant, Cliff Jessup, Judge.
All right. Scheduling status conference. We need a new trial date.
Well, Your Honor, we're done with paper discovery. We're done with depositions. We got the insurance policy from where this gentleman worked. I sent out a claim letter. If you remember last time, you ordered them to get us the employer's insurance policy. I sent out a letter for a claim. I think we got a claim now filed with them. And Mr. Jessup, I don't know if you asked them to provide a defense at all.
I don't think I got the insurance information, but we will be asking them to take over the defense, Judge, for sure.
So just before mediation, we probably need a new trial date. Just before mediation, if you give us a little time, Your Honor, we can probably get the other insurance company on board, go to mediation, probably resolve the case, Your Honor.
What are these hearings that I have? Motion for protective order and a motion to quash. Am I looking at the right case?
Well, what they want to do, they meaning the employer that this gentleman worked for. I had noticed their deposition originally to get the insurance policy and some other things. Now that we got the policy, I don't see the need for the hearing, but they still want to have it. They meaning we didn't sue them. It's his employer that filed that protective order motion.
Okay. Well, those are set. I am going to reset the scheduling status conference for now to coincide with that date, whether we actually
Your Honor.
or not, we'll do that. And then
That's great.
see where we end up, okay?
Yeah, and Mr. Jessup, I'll get you all the information.
Yeah, that would be great. I'd appreciate that, Victor.
Thank you. And Your Honor, this is my son, Zachary Biganowski, recently joined us.
Welcome. I remember him from the last.
Okay. I didn't know if I introduced him, Your Honor.
Thank you, Mr. Biganowski. Welcome again, and we'll see you all in October.
Thank you, Your Honor. Thank you, Mr. Jessup. Okay.
Who's next?
Judge, jumping to page 4. Calling cause number 2025 DCV 2785, Alma Gasca versus Williamton Savings Fund Society et al. Announcements, please.
For the defense, Senator Cox.
Vivian Lopez for defendants, Carrington Mortgage and Wilmington Savings Fund.
Oh, wait, I'm sorry, Your Honor. I got ahead of myself. I'm on the next one.
Want to be on all the cases?
No, thank you, Your Honor. I have enough as it is.
Okay.
And Hector Perez here on behalf of the plaintiff, Judge.
Mr. Gutierrez, what are you doing here? I don't see you till 1:30 on Wednesdays.
Oh, that's
Right?
true.
Or 2:30. 2:30.
That's true. I'm a bit early, Judge.
Okay, here we are. Let's see. Mr. Gutierrez, plaintiff, Ms. Lopez. Anyone else? No, not Mr. Cox. Okay. Scheduling status conference. How are we doing on this one? You want a trial date?
Judge, just to give you some background, there's one party that remains to be served in this case. I had served the other parties. I guess I just overlooked the fact that there's one more I had neglected to get done. I filed a request for citation. I should be receiving that soon. And we'll get that last party served. It's Launch Base Properties LLC. And I believe I had also filed a non-suit as to AVT Title Services.
Okay, see, that was filed yesterday.
Yeah, so there's 3 remaining parties. I think the counsel for the other 2 parties are here as well, Judge.
Okay, so I'm thinking we're going to reset the scheduling status conference for 45 days. I don't want to push too much farther than that to see where we are. We'll go from there. Sound good?
Yes, Judge.
If you need anything outside of that date, let me know.
Thank you, Judge.
Thank you for appearing. Have a good day.
You as well.
All right, who's next?
Judge, let me bring in Erica Vasquez Pro Se for the next one. Bottom of page 4.
And did our ad litem, I showed there's an ad litem here? Is that right?
Your Honor, the ad litem on this case is Diana Valdez, I
Uh-huh.
believe.
Okay. Where's Miss, go ahead and bring in Miss Vasquez.
She's admitted, Judge. She's
Oh.
Ms. Vasquez, are you there?
I'm sorry, I missed it.
Erica Vasquez?
Did Miss,
No,
did Miss Vasquez?
it's looking like her audio may not have connected. I'm not seeing a mute button.
Yes, sir. You're correct.
Let me. Do we have anything for Miss Valdez? Why is she not? Was she not?
That I don't know. I think
There she is.
There she is. There she is.
Okay.
Are we early? No, we're right on time.
No. No, we're actually okay. There she is.
Good morning, Miss Valdez. How are you?
Fine, Your Honor. My apologies. I was having some technical difficulties on my end
No worries.
to log in.
Sometimes I don't know if our ad items, how they get noticed, or so I was just asking, just in case. But
Okay, terrific.
Miss Vasquez is not connected here. I don't think. Is she connected?
I can see her, but I don't see her image. I just see her.
Yeah.
Under.
I think what they saw was that she's not connected to audio.
I think that's
I
her,
see.
Judge. Trying to come in on an iPhone.
Okay, let's see.
Yeah.
Let's see. So we're
Hello, Ms. Vasquez, are you there?
And Judge, I should let you know that Miss Vasquez is Spanish speaking.
Okay.
Señora Vázquez, ahí está.
Sí, aquí estoy, es que no me podía meter.
Okay. Señora Vázquez, sí puede iniciar eso, su video. Okay.
Sí.
Bueno, no habíamos pedido un intérprete para esta audiencia. ¿Tiene alguien ahí con usted que le puede explicar lo que va a suceder? Porque a veces mi español está bien y a veces estoy súper limitada.
Sí, aquí tengo, no se preocupe.
Okay.
Permita.
¿Quién está ahí con usted?
¿Mi hija?
¿Quién es su hija? ¿Es un adulto?
Sí.
Okay.
Leslie Vázquez.
Okay. Let's go ahead and call it. This is 2025 DCV 2822, Erica Vasquez, as next friend of NV and minor versus Celestina Duda de Garcia. May I have announcements, please?
Your Honor, Sanford Cox for the defendant.
Ms. Valdez, if I can get your announcement.
Yes, Your Honor, Diana Valdez. I'm the ad litem for the minor in this case.
And Miss Erica Vasquez is appearing today, self-represented. However, as she has indicated off the record, she is a Spanish speaker, and we do not have an interpreter here for today's hearing. So I'm understanding that Ms. Vasquez has an adult family member there that can help translate for her in English and into Spanish. And I will certainly attempt to do some that is not part of the official record. Señora Vázquez, nomás anunciaron los licenciados para la defensa y la que está apuntado de la corte para representar los intereses de el menor persona en este caso, ¿ok?
Sí.
This I don't know. ¿Cómo se llama su intérprete, su familiar, señora?
Leslie Vázquez, es mi hija.
So Miss Vasquez's daughter, Leslie Vasquez, may be trying to interpret some things. Mr. Cox, are we on this?
Yes, at this point, I think I need to defer to Mr. Valdez. I'm not sure how far she's gotten through with the work that she needs to do.
Yes, Your Honor, and if I may, so I am currently working with Ms. Vasquez. She has come and provided me with copies of all the medical records, the bills that she has in her possession. And so my office is in the process of trying to help her achieve some reductions, because obviously our goal is to maximize the amount for the benefit of her daughter. And once we know how much will be left after we hopefully can receive some of those reductions, I'll be in a better position to determine, the appropriate option for her, because my goal as an ad litem is always to try to maximize what is available. Obviously the court registry is always an option. Personally, it's my least favorite option because the rates are so low and they fluctuate. And so that's where we are. So we were able to meet with Ms. Vasquez last week, and she is allowing us to communicate with those providers on her behalf to see if we can assist in that regard.
What kind of timetable are we talking about, Ms. Valdez? Is 60 days good enough, or do we need more time than that?
Actually, no, Your Honor. I was going to propose 30 to 60 days, which should give us plenty of time.
I think I'm inclined to do 60 days. Are you asking at that 60-day time table to proceed on a friendly suit or to have another?
Yes.
Okay.
Yes.
So let me see if I can explain this in some way to Ms. Vasquez. Señora Vázquez, no sé si su hija Leslie le puede explicar lo que representó a la abogada Valdez. Es que está trabajando en su caso para poder dar el mejor opinión donde lo que sucede aquí es lo mejor para el menor, me imagino su hija o hijo en este caso, y que ustedes tuvieron una junta la semana pasada y van a continuar a trabajar para que la abogada Valdés puede hacer el trabajo que se dedica en este caso. ¿Sí entiende eso?
Sí.
¿Me expliqué? Ok. Entonces, ella está pidiendo más tiempo, poquito más tiempo para terminar ese trabajo, y le ha pedido a la corte 60 días, entre 30 y 60 días para la corte. Le voy a poner una audiencia en 60 días donde podemos tener una audiencia, se supone, final en lo que va a suceder en este caso. ¿Ok? So what I explained to her is as best as I could, what Ms. Valdez explained, indicating that the ad litem is going to continue to work on the case and that we will have a friendly suit, a final hearing in approximately 60 days. So with that, señora Vázquez, ¿tiene alguna pregunta para la corte en este momento?
No.
I'm
No,
asking if she has any questions for the court at this time. She does not. If there isn't anything further, then I am going to adjourn and set this for friendly suit in about 60 days.
Very good.
Thank you, Your Honor.
Señora Vázquez, la audiencia que vamos a tener en 60 días, más o menos, va a ser igual como hoy, en Zoom, con la misma conexión y todo, ¿ok? Todo va a ser igual. Si tiene preguntas, puede hablarle a la coordinadora de la corte. Se llama Mirna Hernández, aquí en la corte, ¿ok?
Sí, muy bien.
Very
Muchas
good. And
gracias.
Judge, if I may, while we have all the parties online, just for a few housekeeping matters for the friendly suit, will you require a virtual or an in-person hearing, and will you require the minor to be present just so we can make sure, she's not in school. She's in the 8th grade right now, presently.
So I require neither, but I will accommodate whatever you all would like. So for example, I'm happy to do them remotely, but if there is a request to do it in person, just let us know and we'll schedule it in person. I do not require the minor to be here, but if they're available, great. But I certainly understand if they are not.
Okay, terrific. Thank you, Judge. And we'll be sure to have an interpreter present for the friendly suit hearing to take Ms. Vasquez's testimony.
I appreciate that. Thank you very much.
Okay, thank you.
Thank you. Señora, ya se terminó la audiencia, ¿ok? Se
Sí,
puede
muchas gracias.
a usted.
Sí, gracias. Buen día.
Thank you all. You're adjourned.
Okay, bye-bye.
Bye-bye. Thank you, Ms. Valdez.
Thank you.
Okay, who's next?
Judge, on page 3, calling cause number 2025 DCV 0176, Maria Cano et al. Versus Juan Rivera. Announcements, please.
Christina McLaughlin for the defendant. Your Honor, and I'm sorry, I just checked the portal and it looks like the notice of non-suit was filed yesterday.
Oh, okay. So I have an order too somewhere?
Well, I don't see an order. I'll reach out to plaintiff's counsel and see if they can forward one.
Please do. Thank you. I know you were waiting.
It's okay. Thank you, Your
Haven't
Honor.
seen you in a minute. Take care.
I know. I hope you're doing well, Judge.
You too. Bye-bye.
Bye.
Who's next?
Judge, I need to find out why Miss Fletcher's here. Hello, Miss Fletcher, are you there?
Yes, hi. Can you hear me?
Hi, what case are you here on?
So actually, as I was sitting here, I recognized that I believe that we received an order subsequent to this. So this hearing may have been reset, but let me pull the cause number. It's 2024 DCV 4927. It's ProTech Roofing Systems versus EMJ Corporation. It looks like there was an order setting status conference for today, but it looks like we subsequently received an order setting hearing for October 8th, but did not have a chance to call and confirm with you all that today's was off. And so wanted to hop on really quickly and just confirm, but I don't see opposing counsel here. So I'm assuming that the October 8th order setting hearing supersedes the prior notice.
So I don't see you on the docket. So I'm gonna assume everything you're assuming is correct.
Okay,
Does
perfect.
anybody see that one? I didn't look it up. I didn't look up the cost number.
It is set to our October 8th to reset.
Thank you very
Okay.
much. Have a good
Great.
day, Ms. Fletcher.
Thank you. You as well.
Bye-bye. Who's left? I feel like just went too fast.
We have an 11 o'clock, Judge, where they haven't set up yet.
That's a pro se as
On
well.
page 6, yes, ma'am.
Who's the, okay, so we're early. We can
Yes,
take a
ma'am.
break. We can take a break. Thank you.
Hello, Mr. Palm, are you there?
I am.
Hi, sir. I'm gonna put you in the waiting room until the hearing starts.
Okay.
Please don't
No
leave.
problem.
Okay? Please don't leave. I'm gonna bring you in when your hearing starts, okay? So just stay in the
Okay.
waiting room and please don't leave.
Just be aware I'm at the Dallas airport, so my connection could be a little iffy.
Well, it's pretty good right now, so just
Okay,
hang out
cool.
there and as soon as it starts, I'll bring you in, okay?
All right. Very good.
Hello,
Good
Ms.
morning.
Mendez.
Good morning, sir. How are you?
Are you covering something else or?
Yes, I have another one right now at 11 on the Palm matter, PALM.
Great. Okay. As soon as the judge gets back on, we'll hear. She'll hear it. Okay.
Okay, terrific. Thank you.
Okay, he's here too. Okay, thank you.